News. And I am joined today by the always interesting, very smart, and seemingly tireless Noah Feldman. He's a law professor at Harvard University. He is a prolific writer and thinker. Noah and I, in different forums over the last few years, have talked about the various journeys Donald Trump has been experiencing through the US legal system and the courts. And of course, we're here to talk this morning about the guilty verdict that was rendered yesterday evening against Trump in his New York criminal fraud trial. Noah, welcome.
Thank you, Tim. It's a pleasure to be here on any day, and this is an historic one.
It is a historic one. Donald Trump is the first former president to be convicted of a crime. And there's so many nuances to this case. You and I think last fall, looked at the totality of his cases in a podcast we did together. And I'd like to come back to that framework, but let's begin today zooming in on this case. And I think when last we talked, you and I both agreed that of the 4 criminal trials Trump was facing, this one was the weakest, the least muscular. It had the weakest legal foundations of any of the cases. And in this case, in the Manhattan District Attorney's prosecution, they alleged that Donald Trump doctored business records to cover up payments to 2 former paramours in order to keep them from telling their stories to the press on the belief that if they did, it would derail his 2016 presidential campaign. The argument of the Manhattan District Attorney was the cover-up amounted to documents fraud and business records fraud, but became a much more serious crime because it also led to unlawful campaign contributions and election interference. I think that little leap is where a lot of the tensions arise, but not a little leap, a significant criminal leap. Tell me, has anything that's transpired since last we talked given you a different view of this case or a more robust view of it?
That's a great question. I think when we spoke, we also agreed that on the facts, the prosecutors were very likely to get a conviction in this case, and that because it's not a federal trial, but a state trial, it had a high probability of actually going to trial. And sure enough, that turned out to be the case because the Georgia trial, though also a state trial, has gotten derailed by, I don't know if this is the technical term, but the hijinks of the lead prosecutor and the person whose job it was to hire the lead prosecutor. And Trump's legal interference has successfully slowed down both the Washington, D.C. January 6th case and the federal court in Florida's retention of secret documents case. So I think what I would say is that this is the case that ended up making history with all of its limitations as a legal case, and also with all of its narrowness relative to the actually very bad things that, at least in my view, Donald Trump has clearly done. This is last on the list of how bad the things were that he did relative to the other cases. But this is the one that actually went to a jury, and 12 peers decided that the former president was guilty of 34 felonies.
Two of whom were lawyers, Noah, on the jury.
Yeah. So to me, the first, that sort of major takeaway of what's happened is our criminal justice system worked in at least one place. It happens to have been New York City. And, that's the place where Trump said he could, shoot someone on Fifth Avenue and nothing would happen to him. Well, this was much less serious crime than that. But in fact, New York State and its people held Donald Trump legally accountable. And that has not happened before, despite all the things that he's done, despite 2 impeachments, each of which led to Senate not convictions. This is an actual conviction. And that's historically meaningful and significant no matter what else happens. And so I guess I would say that, notwithstanding all of the worries and concerns and criticisms that I think we rightly had and will probably recur about this particular case.
It's always, I think, worth remembering that the case wasn't built out of thin air. I think there's been, insinuations from Trump supporters and critics of the case that it's a fabrication, it's a witch hunt. There was no meaningful fact pattern here, but in fact, there was a quite tangible, there was a quite tangible and fact-based body of evidence here that actually I sat through the much of the trial, and while Trump's defense attorneys tried to pin, I think unsuccessfully, and I think in a strategically unsound way, tried to pin the entire defense on discrediting the testimony of one of Trump's former lawyers and fixers, Michael Cohen. Ultimately, the prosecution's argument didn't rest on Cohen's testimony or any individual's testimony. It really rested upon this big documented body of evidence that transcended the testimony of all the witnesses. So in the end, the witness testimony colored in moments. It gave texture to conversations, but I don't think the prosecution's case rested on it. And oddly, I don't think the defense was ever really prepared to take that on in a sophisticated and aggressive way. And I think it serves Trump poorly.
Yes. Had I been defending this case and not been constrained by the former president's, personal demands, which is a pretty big if, I think I and a lot of other lawyers would have focused on arguing to the jury that ultimately there was no real crime here because there was an attempt to pay off to people in order to avoid the personal embarrassment or the difficulties in his marriage. And that on that view, the worst thing that you could say would be that there was a misdemeanor of falsification of business records. And I would have also tried to emphasize a lack of knowledge on the part of Donald Trump of the events that had occurred. Now, I don't know if either of those arguments would have worked, and there was a fallback that you'd end up with just a misdemeanor conviction, but obviously the defense didn't follow either of those courses of action, probably on the first because Trump was apparently telling them, I want to just deny everything still to this point and say it's all a conspiracy, which was not plausible given the evidence. And then he didn't want any kind of a conviction, misdemeanor or felony. And also, presumably, he didn't want it said that he didn't know what was going on in his organization. I mean, had he made that argument, it would have been entirely, I think, believable to many people that not every check written to every person in a business that has hundreds of millions of dollars going through it is personally supervised by him. But he didn't want to say that either. So, that's kind of remarkable. And it's why this was a weirdly defended case. And it's probably part of why there was a conviction.
Even if he didn't want to say that he signed off on every bill that went through the organization, in 9 of the 34 felony counts, he signed checks that were in 9 of those counts. So that would be a hard reach, I think. The other thing is, while he, as you say, I think it was foolish of them to simply deny, when in some cases, Trump had publicly said quite some time ago, for example, that he paid Michael Cohen. And so he was contradicting either statements he had made publicly or on social media that ran against what they were trying to defend in court. His attorney, Todd Blanche, who is a novice defense attorney, I think he was brought into this action because he has loyalty to the orbit of advisors around Trump, rather than necessarily being the most capable person for a defense like this. He said in an interview, I believe it was on CNN last night or this morning, I didn't see it till this morning, but he was asked, who drove the legal strategy? Was it you or was it Donald Trump? And Blanche said, well, we did it together. We conferred with one another and we came up with the strategy together. And of course, Donald Trump doesn't listen to anyone. No one confers with Donald Trump. When you work for him, you take orders from Donald Trump. And watching how this played out in court, I think his orders were deny everything, including that I had any kind of an sexual encounter with these 2 women. And I want to embarrass the witnesses on the stand, and I want to make a mockery out of the court and out of the process. That's my strategy. And obviously, that came back to haunt him in enormous ways.
What's really fascinating is, we're talking about someone who has been more skillful in the I'm just going to baldly lie strategy than any single person in the history of the United States. And I'm including P.T. Barnum, in that category. And, on a whole different scale of getting away with just looking everybody in the face and saying the thing which is not. And he's done it again and again, thousands upon thousands of times. As you showed, Tim, this started long before he ran for and became president. But it really, I would say it ramped up in recent years. And so if that's your whole life strategy, it would be surprising if you were sophisticated enough to think that in this very different context of a courtroom, where there are jurors who actually are presented with evidence, who are obligated to sit there and hear the evidence, that you would get the same result that you sometimes get on the national scale. And so to me, it's simply Trump taking the strategy that, again, as you've shown, was his life strategy, but also that has worked bizarrely well at the national level, and just continuing the same strategy in a courtroom where it's not well designed to work, where there are professional people and the prosecutor side. And we should credit the District Attorney's Office of New York, which it prides itself on being the best prosecutorial office at the state level in the United States, and certainly has the alumni of that office to prove it, and brought in lots of amazing people, some currently in the office, some formerly in the office, and put together a very strong team and just did their jobs, and they won the case. And in that sense, you could say that, at least in this context, our criminal justice system, much maligned in the world, including by Donald Trump, worked in this specific instance. Now, that's a separate question from whether our broader system can take into account the fact of a criminal conviction and incorporate that into the democratic process. That remains to be seen. And I would say, actually, our national vulnerability is meaningful here. It's bad enough to have elected Donald Trump once, bad enough that he is the Republican candidate for the presidency now, and it will be very bad indeed for principles of rule of law if he's elected. It'll now be worse if he's elected than it would have been absent a criminal conviction, because then the American people won't just have been electing someone who boldly lies, they will be electing someone who has been convicted of felonies in court. And so, at the broader level, there's still a real question about how our system as a whole will incorporate the fact of the conviction. But at the micro level, the criminal justice system in this courtroom in this moment worked the way it is supposed to work.
Man, oh man, we have so much to unpack here. You made such a great point earlier on about Trump's modus operandi for decades. He turned 78 in June. And for at least 5 decades of his 78 years, he's been getting away with this carny act in public of lying or embellishing or exaggerating to create his own narrative about his life and his actions. But that is not a strategy that usually survives a courtroom appearance, as you noted. And it's so useful, I think, when you think about how some of the prior investigations of Donald Trump came up short of the courtroom. I think Robert Mueller, in his probe of the Trump campaign's interactions with Russian operatives during the 2016 campaign, was very detailed, granular, very well thought out. Robert Mueller's a responsible and responsive investigator. He ultimately said, I don't have the powers to take what I've discovered into a courtroom. If the U.S. attorney in New York wants to do it, it can. If Congress wants to do it, it can. And I'm not going to go beyond that. And of course, no other bodies decided to take up the body of evidence Mueller had assembled to take Trump into a courtroom and test the fact pattern. He got impeached twice by the U.S. Congress, but it was decided by his Republican allies in the Senate not to bring that into a trial and to test the fact pattern again. And then, as you noted, the other 3 very important criminal cases have all been stopped up. I think horrendous judgment by the prosecutor in Georgia, and then I think judicial ineptitude or possibly malfeasance in some of the other cases, in the 2 other primary cases. Those have yet to see their day in court, but he did see his day in court here. And as you note, I think we could take heart as a country in the idea that a forum in which a fact pattern is laid out and responsibly presented to a jury of responsible fellow citizens, a just and transparent conclusion was reached that had nothing to do with a witch hunt and everything to do with holding Donald Trump finally, I think at long last, accountable.
Tim, we have
Go
a
ahead.
request here from a viewer to talk a little bit about the appeals process, wondering, what would happen to Trump in the appeals process. So shall I just sketch that out quickly?
Yeah, and let's just give our audience a quick look at that. To me, it will hinge on, and I'll let you go, Noah, is these misdemeanor, these felonies about record cover-ups became felonious by connecting them to election interference. And that leap is what has given some observers concern, and that might be the groundwork for an appeal for Trump's side. So go with that.
So I agree, Tim, and I'm happy to talk about the dirty details of what that would look like. Let me start with what the process will be. Trump will be sentenced. He's scheduled for sentencing on July 11th. And at that point, we'll find out whether Judge Merchan will go with the hardline approach, which would enable him to sentence Trump to prison time, or would say that because this is a first offense in a white collar case in which there is no classic victim, that is to say, no money was taken from anyone or deprived from anyone who was rightfully due that money, that he wants to go with some form of probation. So that's the first juncture that we'll cross, and there's a lot more to be said about that. And then Trump will have to appeal in the following process. First, he has to appeal to the appellate division in the New York state courts, which is a kind of intermediate level of review. If that court upholds the conviction, which for reasons we can talk about, I think is very likely, Trump would then go to the New York Court of Appeals, which is the highest court in New York. It's sometimes confusing because in New York, the highest court is not called the Supreme Court. The name of the trial courts is Supreme Courts, just because New York wants to mess with everybody. So the highest court in New York is New York Court of Appeals. Again, my own view is that it's very likely to uphold the conviction because the trial judge followed New York law very clearly in framing the charges here. And then comes the real wild card. The only way you can appeal a state criminal conviction to the US Supreme Court is if you can convince the Supreme Court that there is a federal constitutional issue. In other words, that it's not just that they got it wrong as a matter of state law, but that the way that the trial court got it wrong violated the US Constitution. And that's a hard case for Trump to make.
What would they cite? What would they cite in that regard, Noah?
So what I think they would say is that so as you've been mentioning, the way Trump's crimes went from misdemeanor to a felony was the jury had to find not just that he falsified business records, but that he did it with the intent to cover up a crime. And then the question is, what was that crime? And Judge Merchan instructed the jury correctly under New York state law that they didn't all have to agree on which of Trump's various wrongful acts that he was trying to cover up was the crime. And the prosecution offered a number of options that I think you've already mentioned in our conversation, Tim. They mentioned illegal campaign contribution. They mentioned attempt to defraud the voters in some indirect way by virtue of misleading them. But the point was they didn't have to all agree and decide beyond a reasonable doubt on a specific one of those underlying crimes. So what Trump's lawyers would probably argue, what I would argue if I were his appellate lawyer, is that the US Constitution in its due process clause requires that when you go to trial to be convicted of a crime, the specific charges be specified against you and proven beyond a reasonable doubt. And so I would argue that although the falsifying business records was specified, because the jury wasn't told they had to agree on a specific underlying crime, the part that bumped the case from a misdemeanor to a felony was constitutionally invalid. Now, this is a thin reed argument because of the difference between state and federal law. But if the Supreme Court were inclined to save Trump under those conditions, I suppose they could say that, yes, we consider that to be a violation of the federal Constitution sufficient for us to hear the case. And if they said that, then they would decide the case, say that the conviction was inadequate on the felony part, and then it would go back to the trial court to do it over again. So, again, no certainty that they would actually do such a thing, but that is the scenario where the US Supreme Court could potentially get involved. Do I have you back there, Tim? I will. I'll continue to the conversation then until the answer, until you're reconnected, Tim. What I would further say is, I think, important and relevant here is the question of whether Trump will be sentenced in such a way that he ends up having to go to prison while he is president of the United States. And the reason this is so important is that usually a court would not send someone recently convicted of a felony like this to prison until their appeals were over. So whatever sentence Judge Merchan gives on July 11th, assuming it's a prison sentence, ordinarily would not require Trump to be sent to prison right away. He would not have to go to prison until after his appeals were exhausted. And that will take many months and possibly well over a year. So if Trump is elected president of the United States in November and is sworn in January, we could actually have a scenario occurring in the real world in which Trump was sitting in the White House and then formally was obligated to turn himself in to the New York Corrections Department for incarceration in a state prison. And that would be one of the strangest and oddest events to have happened in US history. And it would pose on the surface a very hard constitutional question that's never been answered before. Namely, can the president either A, convince the state courts to suspend his sentence, his criminal sentence, until after he's done being president? That's never been done before. So that would take an extraordinary act either by New York's legislature, which my guess is would not be sympathetic, or by the judge, the trial judge, again, not very likely to be sympathetic. Or absent those, Trump would have to go to federal court and ask the federal courts and ultimately the Supreme Court to reach the outcome in which it would order the New York courts to stand back and let Trump serve out his presidency and only go to prison afterwards. The alternative scenario, which is hard to conceive of, but legally is defensible, would be that Trump really would have to go to prison while he was president. Now, what happens then? Can he still continue to serve as president while he is in prison? Legally, there's nothing in the Constitution to prohibit it. It could be determined that he is just unable to function as president during that period of time, in which case the vice president could cover for him during that period of time. There's a provision of the Constitution that allows that to be activated. So that would be one possibility. Or, knowing Donald Trump, he could try to still be acting president of the United States from a prison cell. And that's a kind of absurdity that's genuinely almost impossible to imagine, but it's legally something that we're in line for. I mean, that could actually happen as a matter of law. Tim, we see you at least momentarily there. But I will, in the meantime, continue to talk about the case here. I think a really interesting question that we've also been asked is, what were the surprises in this criminal case? And to me, apart from Trump's defense approach, which, as we said, maybe shouldn't have been seen as a surprise, the other surprise is that for those who sat in the courtroom, and Tim among them, I think the general experience that most people have had is that they saw a case that actually ended up seeming very powerful, even though in writing, most of us legal observers have thought the case wasn't all that powerful. And I think that's because of the way a trial, in fact, works in the real world. In the real world, the way a trial tends to operate is that if you're in the room, a narrative is created that is usually extremely convincing, provided that the evidence is behind it. The tricky part is that most people aren't in the room. And so there's a kind of disparity between what, say, a casual observer would think, or certainly a viewer of Fox News would think, and then what someone in the courtroom sees. And usually that's socially desirable because we want such decisions to be made by the jury and not in the media. But in the case of someone who's running for president, is going to continue running for president, and has been president, the public perception may turn out in the long run to be even more important than what happened in the courtroom. So what are other important landmarks in this case? And let me ask viewers to feel free to ask questions. And if you do, I will do my best to answer them, and as will Tim when he's able to reconnect. To me, the really grand question that we face now is the adequacy of the legal system to interface with the Constitution and with our political system. So you might say that until now, Donald Trump has been on trial, but now that Donald Trump has been convicted in this case, it's the rest of us who are going to be on trial. It's democracy itself in our country that's going to be on trial. Hi, Sarah. I'll finish my point and then hand it over to you, Sarah. To me, I was just saying, Sarah, that I think that until now, Donald Trump has been on trial, but now the rest of us are going to be on trial. Because the question now is not what is a crime. We know what a crime is. The question is, do we as a country have the democratic capacity to say that being convicted of a felony is serious business and should disqualify you from being president of the United States? And for that, we're not going to be able to rely on a court. We actually have to go and vote and decide that. And on that, I mean, the polls will help us get a sense, but it is far from clear that we're capable of passing that test as well as the New York State courts have passed this test.
Thank you for making that point. Yeah, I'm wondering here about next steps. So the sentencing is July 11th. I think this is going to be something that people watch very apprehensively. I'm wondering if you think jail time would be sort of usual here, if we can set aside the issue of this being a former president. You know, it is a first offense that he's been convicted for. It's a white collar crime. You know, is it reasonable to expect jail time? I can't imagine, you know, what would be going on through Judge Marchand's mind at this moment.
Great question. I have been talking, as I have throughout this case, not just to other lawyers, but to specifically lawyers who've spent their careers prosecuting similar cases in the same courtroom. So that is to say, people who are veterans of the District Attorney's Office of New York. And what I have been hearing from them is that in similar cases, probably the average is around 50% of judges would give jail time, and that there's a lot of individual discretion given to the individual judge in a case like this. Because on the one hand, you could categorize this as 34 felonies, an attempt to deceive the people of New York and of the United States, underlying criminal conduct question, in which case jail time is clearly appropriate. Or you could say, effectively, this is an accounting crime, you know, of creating false business records for your own books in the accounting, that there's no allegation of tax fraud, so the taxpayer didn't lose any money. There's no allegation that the payoffs themselves were unlawful. And so the basic conduct of the payoffs wasn't unlawful. So what was being concealed wasn't a crime in that sense. It has to have been a crime in some other sense. And if you frame it as a first offense, white collar crime that's essentially victimless, then many judges would not give jail time. It's also not a felony that's that frequently prosecuted, to be blunt. You know, falsifying a business record where the business record is your own books, you know, in your own accounting, and there was no one you were trying actively to defraud for money. There was an intent to defraud here, but not for money, but for some other purpose. So a lot of it, as is often the case in sentencing, is how you frame the case. Mm-hmm. And so again, the people I know who've been prosecuting these cases in the same courtroom say that they think it's a close call. Judge Marchand is known to be committed to real punishments for white collar offenders. He's not soft on white collar offenders. And so he may well be someone who decides to give prison time. On the other hand, the whole world is watching. And as I mentioned earlier, a criminal sentence of prison might precipitate a national constitutional crisis because of the question of does the sitting president go to prison? But a probation sentence would not have that effect. Neither would some symbolic sentence, some 30-day sentence sort of thing. And so that still might if he were already president when that happened. So, if I were the judge, I would also be thinking of the national implications. And I might think it's part of my job to avoid precipitating a national constitutional crisis. And that might put a thumb on the scale towards a probation sentence rather than a jail sentence.
Mm. One of the sort of undercurrents here that I think I've been apprehensively waiting for is whether there will be some sort of, I hate to say it, but outbreak of violence. We know there have been violent protests associated with Trump before. Sorry, I'm hearing some background noise there, Mary. Thank you for bearing with us. And I guess I'm just wondering where you think this leaves our democracy. The judge has asked the jurors to keep their anonymity. If I were the judge, I'd be very worried about violence against myself. What does this say about where we are as a country?
The worry about violence tells you a lot about concerns that we have and should have. So far, though, that hasn't happened. And I tend to be an optimist about such things until they go wrong, at which point I allow people to tell me I was too optimistic. We've had high-profile people convicted of lots of crimes, and it's relatively rare for people to go after the jurors, especially if they do successfully preserve their anonymity. And Trump himself has different ways to play this. He could play this as, let's go get the judge, let's go get the jurors, and I'm sure some of his followers would respond to that. But that might well backfire on him. He may be much better off just now acting like this never happened. And so he may lean into it and say, I'm a victim. He may say he's a victim of a faceless system, which sounds a lot more compelling than being the victim of 12 random New Yorkers. In which case the jurors are probably fine. Or he may just say, who cares? This was kid stuff. It didn't mean anything. And we'll see which way he goes. So far, his hint has been that he might lean into it. But it's not obvious that, he has an interest in going after these 12 people or the judge or the prosecutors any more than he has already done, especially because, to be blunt, he's now very vulnerable. After his sentence, the opportunity that he will have to stay out of prison while he appeals is not his as of right. It's in the discretion of the judge. So if he goes after the jurors, the judge will order him put in prison when he is not yet president of the United States. And his lawyers will make this very clear to him. So Trump is actually, this is the last point I'll make, and I think we're going to wrap up. Trump is now, just legally speaking, in a place he's never been before. I mean, to be very blunt, the judge now owns his liberty. If he does anything that annoys, harasses, intimidates anyone, we're not going to be seeing another criminal fine. At that point, a convicted felon will have done that. And to support the legitimacy of the judicial process, Judge Merchan will have to order him sent to prison. Not temporary jail, prison. And he will know that, and like all other human beings, he will not want to have that happen to him. And so I think there's the greatest possible incentive on Trump not to encourage his followers in any way, shape, or form to go after the jurors or the judge. Sarah, thank you for pinch hitting here. I'm grateful.
Thank you for all your insights and for bearing with us through some of those technical difficulties. Thanks for everyone for watching. And you can read more from Noah Feldman on Bloomberg Opinion. Have a great day.